looks like everybody has rolled in. We got about 23 people online right now. There may be a few others that join us. I'm Carl Klein. I'm with the Washburn University Small Business Development Center out of Topeka, Kansas. And I have today with us the Washburn University Transactional Law Clinic team, headed up by Professor Janet Jackson. Raise your hand, Janet, so everybody knows who you are. You're a TV star. See her a lot on KTWU. We appreciate what she does for us and joining us today. We also have a team of the 3L law students from the university that are joining us. They're going to be presenting to you on legal issues and your small business. And as Janet and I were talking beforehand, she's been doing this for probably 14 or 15 years, and I've been involved with it, I think, for 11 of those years. And we usually do it twice a year. We missed a little bit last year with COVID, but now we're back on track. And I think this is a great format for bringing this information to you. They're going to roll out a PowerPoint that really walks through everything in regards to legal issues in your small business from A to Z. You will be emailed a copy of this PowerPoint after the presentation. So no worries on that and getting it to you. The presentation is 58 slides. It goes pretty quick. During the presentation, we ask that you hold your questions to the very end. At the end, our facilitator will come back online and you can raise your hand, and Mindy, our facilitator, will unmute you and you can verbally ask your question. There will also be an opportunity to ask it in the chat function at that time. So look forward to visiting with you. If the Washburn Small Business Development Center provides no cost one-on-one assistance. If anything comes up that you need some help with after the presentation that I can assist you with, just look us up at washburnsmallbusiness.com and contact us, and we'll be glad to connect with you and help you in any way we can. That said, I'm going to turn it over to Janet and her team. Thank you.
And I'm going to turn it over to the students. Okay, I think we're ready.
Oh, here we go. Can everyone hear me? Technology issue.
We can hear you.
You're on now, Jessica.
Excellent. Good afternoon. I'm Jessica Freeman. My team members are Cheryl Hearn and Tyler Loddick. We're student interns from Washburn Law, working in the Small Business Transactional Clinic under the supervision of Professor Janet Jackson, who's a practicing attorney. Tonight, we're going to give a presentation covering the basic legal issues you'll face as you create your business. Mr. Klein already mentioned, but we ask that you hold your questions until the end, and we do encourage you to have a pen and paper handy to write them down so you can ask them at the end. Tonight, or this afternoon, the topics we cover will be ethical and legal foundations for small businesses, choice of legal entities, taxation and reporting, contract formation and enforcement, the CARES Act for small businesses enacted during COVID-19, intellectual property, and employees versus independent contractors. I'm going to start off this afternoon's presentation with ethical and legal foundations for small businesses. So to start, let's first differentiate between ethical and legal foundations. Legal foundations consist of laws and regulations. You can think of these as boundaries or even walls that set up a mandatory legal standards. Laws give us left and right limits. Ethical foundations, on the other hand, are more based off our perception of right and wrong. Ethics can change with the times, but they typically revolve around honesty, respect, and integrity. One way to think about ethical foundations is as a second hurdle that comes directly after you've met the basic legal standards. It's entirely possible to act legally and also act unethically. To give you an example of an action that would be illegal but unethical, let's consider a pharmaceutical company that drastically raises the price of a widely used life-saving drug like insulin. The action of raising the price might very well be legal, but it would leave millions of people who depend on insulin unable to afford it, so it would be unethical. As a business owner, it's your responsibility to both adhere to legal and ethical standards. One A good, solid way to establish an ethical foundation for your business is to develop a strong mission statement that communicates your core values. As an example, I found a mission statement for an ice cream company called Island Ice Cream. It reads, Island Ice Cream Company is dedicated to providing top quality products and excellent service. Customer relationships, value, and integrity are the cornerstones of Island Ice Cream Company's long-standing reputation. We strive to continually improve our business partnerships to maximize profitability for all parties involved. We challenge ourselves to stay on the cutting edge of the industry and use our knowledge, experience, and commitment to excellence to the best of our ability. As you can see, this mission statement lays out an ethical foundation for this ice cream business. It gives customers a glimpse of what this company stands for, and it provides the owners a guide they can always refer back to. Next, I'm going to address each of the business entities. The entities we're going to talk about will be the sole proprietorships, general and limited partnerships, corporations and S corporations, and limited liabilities or LLCs and series LLCs. To better explain each of these business entities, I'm going to use a hypothetical business. If any of you spent time in the South, the best thing when you're out all day on a hot beach is the person that walks around selling frozen popsicles. My cousin Amanda actually did this in Mississippi for a while, so we're going to use Amanda's Popsicles as our hypothetical business. Amanda moved to the South, and she grew up in a landlocked state of Colorado, so she absolutely loved the beach. She went there all the time, and the beaches would be packed with people just roasting in the sun. Amanda quickly recognized just how profitable it could be to sell popsicles on the beach. Amanda bought the necessary equipment and started selling popsicles to beachgoers. With or without intending to, Amanda just created a sole proprietorship. Sole proprietorships are owned and managed by a single person. They can have employees, but the owner is a sole proprietor, and there's no distinction between the business entity and the owner. Sole proprietorships are fairly easy to set up, but they offer no limitation on personal liability. So assets of the business are one and the same as the owner's personal assets. If the owner is sued, those personal assets are not shielded from liability. So it makes it especially important to get the appropriate insurance for each particular business in order to protect the business assets as much as possible. Another way to shield the sole proprietor from personal liability is to keep a business account entirely separate from a personal account. That way, the business assets will be first used to pay off judgments, and your personal assets will be the last resort. Now, you can't register in Kansas as a sole proprietorship, but you can register the name of your entity. Sole proprietorships use pass-through taxation, so any income or business expense from the sole proprietorship is reported on the owner's personal tax returns. And the sole proprietorships terminate at will or when the owner dies. Next, we'll move on to general and limited partnerships. Back to Amanda's popsicle business. Amanda's doing very well, and one of her regular customers notices and says, hey, I'd really like to start selling popsicles with you. You've got more business than you can handle by yourself. Amanda decides she can use his help with the day-to-day operations of the business, so they decide to create a general partnership. General partnerships consist of two people. The two people share the responsibility of managing the business and are always responsible for any debts incurred by the business. They're not required to create a written partnership agreement, but in the absence of one, they're governed by the Kansas Revised Uniform Partnership Act. If they create their own agreement, then they can define the business's distribution, profits and losses, and other management responsibilities. If they don't, the default rules will require a 50-50 share of profits and losses, regardless of what each partner contributed to the business. In general partnerships, like sole proprietorships, they offer no liability protection. The owners, again, are personally liable if the business is sued. Insurance is of great importance for general partnerships as it is for sole proprietorships. General partnerships, like sole proprietorships, can be formed unintentionally through actions, even if no partnership is explicitly stated or intended. So if Amanda's friends just start helping with the business, they may legally be seen as partners who form an unintended partnership. General partnerships terminate when one partner withdraws or dies, or when their partnership agreement says that the business terminates. Next, Amanda's popsicle cart is getting extremely popular, and her success is noticeable. Another of Amanda's customers recognizes this and decides he wants to be involved as well, but he doesn't want to be a part of the day-to-day management. He becomes a limited partner. Limited partnerships are formed with both general and limited partners. In these arrangements, the limited partner has to be established in writing and registered with the Secretary of State. A limited partner is often a silent partner, and their liability is limited to their investment, whereas the general partners who actually manage the business have full liability. Limited partners have to maintain resident agents or offices and file annual reports. Partnerships are terminated by either an event in the partnership agreement or with the consent of all the partners, or when the general partner withdraws or dies. Next, Amanda's Popsicle Cart really hit it out of the park. The popularity for popsicles is known far and wide all over Mississippi, and beaches all over the state are being populated with Amanda's Popsicle Carts. Amanda forms a corporation. Corporations are often called C Corps and are owned and operated by shareholders. They're guided by directors and managed by officers and employees. C Corps have to file articles of incorporation with the Secretary of State and establish bylaws which govern the rights of stockholders, officers, and employees. Because the C Corp is its own legal entity, the owners and shareholders are shielded from personal liability, and there's no limit to how many shareholders they can have. These shareholders are not liable for claims against the corporation. The corporation is required to hold annual meetings and file annual reports. C Corps file taxes as completely separate entities, and they have their own corporate tax rates. They do face double taxation because their corporate profits are taxed, and then the dividends are taxed again. Moving on to S corporations. S corporations are merely C corporations with a different tax treatment. They begin as C corporations, and they require the owners to elect for an S status with the IRS through the filing of a special form. By doing so, they prevent the double taxation that C corps face, and instead of using pass-through taxation, use pass-through taxation like sole proprietorships. S corp owners report the profits and losses in their personal tax returns, and they're required to hold annual meetings. S corps can have no more than 100 owners. Now we circle back to Amanda's Popsicles. Amanda has big plans for her popsicle business. She knows she's going to be successful. She knows that soon she'll be hiring more employees, and she wants to see a popsicle cart on every beach. Amanda needs room to grow, but she's also concerned about her personal liability and that of potential business cohorts. She's business savvy, so she decides to create a limited liability company, or LLC, so that she can tailor her business to be exactly what she wants. LLCs are one of the more attractive business entities for small businesses because they provide a lot of flexibility in how they can be set up while limiting liability for their members. They can be structured to be managed by either member owners or managers, and they require an operating agreement to be filed with the Secretary of State. An LLC's operating agreement is important because it outlines how the LLC will be organized. Among other things, it includes the LLC's legal name, delegation of management responsibilities, and the general governance of the company, as well as all members or owners of the LLC. In Kansas, LLCs can have one member or as many members as you'd like. They do allow for pass-through taxation like partnerships that can be structured differently as well. We won't spend a lot of time on series LLCs, but series LLCs are just LLCs that allow for segregation of different aspects of the LLC. Each series operates like a separate business entity, almost like a corporation. Each series of the LLC can have different members and management and allow for subsidiaries to be set up and segregated without subjecting the other series to risk or liability. These series LLCs also enjoy the liability protection of LLCs. This concludes our discussion on business entities, and next Sherilyn will walk you through the taxation and reporting.
Okay, can everybody hear me? Can anybody hear me?
Yes, we can hear you.
Okay. Thank you for that introduction, Jess. I'm going to cover taxation and reporting, contract formation and enforcement, and the CARES Act. What I'm going to start out with is taxation and reporting. On taxes, if you consider the most disciplined of taxpayers, even in just basic personal income tax, when you imagine that diligent person or persons, this is how a business needs to conduct themselves when it comes to reporting sales, scheduling and budgeting, withholding, managing payroll, unemployment, acquiring and using an employment identification number, etc. The best advice is to do everything. Keep track of everything, report everything. Taxation can be directly correlated to the type of entity that you have, like Jess talked about also. So we have seen during the COVID-19 pandemic that some people have had to, in order to sustain their business that's been affected by the pandemic, they have had to change the type of business they provide. So my fictitious entity is called Able Minds. It is founded by Bob and Joe. and offers online tutoring specific to distance learning during the COVID-19 pandemic. So let's talk about taxation. The state of Kansas requires LLCs and other businesses as well to file an annual report. You can file the annual report online at the Kansas Business Center, or it can be filed with paper using Form LC-50. The annual report is due on the 15th day of the 4th month after your tax closing month. That is specific to every LLC, so everyone's reporting month might be different, and don't get hung up on whether someone else is reporting at a different time. The state business tax, when it comes to income taxes, like Jesse also mentioned, LLCs are called pass-through tax entities. In other words, the responsibility for paying federal income tax passes through the LLC itself and falls on the individual LLC members, which means Bob and Joe would both be responsible for that pass-through taxation. By default, LLCs themselves do not pay income taxes, only the members do. Some states do impose a separate tax or fee on LLCs for the privilege of doing business in the state, but Kansas is not one of those states. In some cases, the owners of an LLC choose to have their business treated like a corporation for tax purposes. This choice is made by filing an IRS Form 2553 with the IRS. Unlike the default pass-through tax situation, when an LLC elects to be taxed as a corporation, the company itself must file a separate tax return. The state of Kansas, like almost every other state, taxes corporation income. Kansas's corporation tax rate is a flat 4% of federal taxable income. There can be state-specific adjustments, plus a 3% surtax on taxable income above $50,000. The tax is payable to the state's Department of Revenue using Form K-120. So Bob and Joe at some point might have to decide if they're going to have employees. If so, they will need to pay employer taxes. Some of those taxes are paid to the federal government. However, Kansas employers also have to pay to the state. So the decision of when taxes can be paid, like I said, they have to be paid by that 4 months after that filing, that your specific start date. However, you can decide if you want to pay quarterly. Some people do that so that the taxes don't sneak up on you at the end of the year. And then when you become so successful that you make enough money, the IRS or the state income tax can actually insist that you pay quarterly. For the same reason, they don't want your debt to pile up and not be manageable. These are decisions that Bob and Joe will need to make, which will then be adhered to as part of their business. So whose job is it to handle this in this LLC? Part of what Bob and Joe have to decide is when delegation is appropriate, when delegation is efficient, and is it better for the company? Like a lot of these topics, Bob and Joe might think my attorney will handle that. And yes, Able Minds does have an attorney, should have an attorney, and especially in the beginning, they will do a lot. But that doesn't mean Bob and Joe shouldn't know how some things work. It's actually best to have an accountant, or perhaps Bob or Joe are particularly skilled in tax matters and ought to be the go-to person for these issues. Attorneys cost money and attorneys take time. Neither of those are things that should be taken for granted by a small business. The more the owners of Able Minds know, the more basic everyday things they can manage without having to call their attorney. The basic bottom line for taxation is to keep track of everything and be transparent. No one expects you to be a tax attorney, and even if you decide you don't have the money for a tax attorney or even a tax preparer, the IRS understands mistakes and they don't expect everyone to know everything. They just want transparency. If they ask questions, and I keep saying the IRS, I mean the Kansas Department of Revenue. If they ask questions, they want answers, and they want the answers to be honest, and that's all they expect. They don't expect you to be a tax expert. So let's see. The next thing we're going to go to is contracts. Contract formation and enforcement. Thank you, Tyler. So contracts are everywhere. Contracts are an important part of any business. The business itself will likely create service contracts between the business and clients. The business might use vendors who are providing the service, and they then enter into a similar type of contract. It's easy to forget that there are contracts with internet providers, phone companies, property managers, virtually all other transactions in business. It would be difficult to run a business without contracts. Able Minds uses contract law to enter into agreements with their clients, who are typically the parents of the children they are tutoring. What is a contract exactly? There are 4 elements to every contract. Those are the offer, acceptance, consideration, and capacity. So I'm going to go over those a little bit using a typical contract for Able Minds. The offer is the services that Able Minds offer to the public. So this is tutoring. Acceptance is basically when any consumer approaches Able Minds and wants to hire them for tutoring service and enter into that agreement. Consideration is payment or virtually anything in trade for that service. Consideration does not have to be money. When someone gives something to another to receive something in return, consideration has been made. Capacity is very important for Able Minds and is precisely why they don't enter into contracts with their minor clients. Able Minds contracts with the parents of the children they tutor. So capacity, any person for a contract to be enforceable, both parties have to have the capacity, whether that be an age thing or psychologically, mental health, infirmity, things like that. So hypothetically, there would be a parent would enter into a contract with Able Minds. They want to have it in writing, even though there are contracts without being in writing, but Able Minds is the type of business that there are specifics to their service they're providing. They want to have it in writing, and they want it to be enforceable. If all the elements of a legal contract are present, there is a contract that can be enforceable. And there does not have to be a signature for so many internet-based formations. When you get gas, you enter into a contract and you have not signed anything or had anything in writing. Able Minds use a written service contract detailing the time and fees involved for every client. Those contracts are signed and have a sample here of how a contract should and should not be signed. So you see here in the first example, it says Bob Smart, President, CEO of Able Minds, LLC, Robert Smart. And that's the correct way. Down below, it just says Bob Smart, Bob Smart. The reason that is not the best way to do it is Bob wants to always keep separate, conducting himself as the president of Able Minds or just being Bob Smart. And especially for that limited liability, he does not want to suggest that he was just entering into a contract himself, having nothing to do with his business, and then he could be more personally liable, and he doesn't want that. So why we talked about you don't have a contract or sign anything when you get gas, but you would have a contract. Able Minds does have written contracts. So why sign anything if you can just enter contracts without having a signature? And that would be because you want to, in the type of business Able Minds is running, there's too many things that would be up in the air. You know, pumping gas is pretty much a straightforward, interaction. Whereas if you're going into business with someone and you have specific things that you want to be ironed out, it would not be a good idea to not have a written contract. So let's talk about unenforceable contracts. Enforceable contracts, we talked about being in writing, and enforcement does not always mean going to court. The business is based heavily on relationships for Able Minds, the tutoring company. Bob and Joe always want to be aware of sensitivity when dealing with children, and it's already a frustrating time during COVID. You don't want to alienate your clients by threatening to sue them. Honestly, the best resolution is not going to court. Bob and Joe developed this business to help, and therefore they should really try and resolve issues regarding enforcement in-house in the spirit of resolution before considering litigation. And that's true for any company. You want to, reach out, make a phone call, touch base with your clients. We haven't gotten your payment, or some other part of the contract is not being adhered to, and we want to find out why, and can we help? Can we get this back on track? So unenforceable contracts, even if everything without going into an entire lesson on contract law, to truly be a valid contract, it's got to be enforceable. Along with the 4 elements we discussed, even if all the elements are present, even if there are signatures and documents, a contract needs to be void of characteristics that make the contract unenforceable. The most common is illegal content. People can't just put anything they want in there, and if someone signs it, it's a done deal if something in those terms is illegal. A good example is landlord-tenant. Some people think if a landlord puts in the contract that they can just do anything. They can come in the house anytime. They can take your things. That's just not true. If it's illegal activity, it doesn't matter if it's in a contract, that contract has to be enforceable. So for Bob and Joe, let's say the client wants the contract to reflect that their child will get an A in the subject in which they're being tutored. This may not be illegal, but it might be considered unreasonable. And reasonableness is a big part of the interpreting any contract or legal matter. Bob and Joe will need to be familiar with their contracts to make sure they are fulfilling their commitments, and just as important, to be aware enough to spot when a client is not fulfilling theirs. Small decisions will be made every day that either keep or breach a contract. And this is another time when they don't want to have to call their attorney every 5 minutes. It'd be much more prudent for them to be aware and really familiar with their contracts so they know when something is not quite right. So next we're going to talk about the CARES Act. COVID-19 has created a lot of hardship for personal and companies. So there are multiple temporary programs available to small businesses during the COVID-19 pandemic. There is the Paycheck Protection Program, which is for employers to protect their employees' paychecks. There's the Economic Injury Disaster Loan, which is geared towards businesses who have suffered some loss of revenue due to the COVID-19 pandemic. The SBA Express Bridge Loans are for individuals who already have a business relationship with an SBA Express lender, and that's up to $25,000. And SBA Debt Relief, SBA affiliated existing loans. So that's also another program where there's already a relationship with the SBA. And despite SBA affiliation, these are all temporary programs that have been created specifically for COVID-19. To look at these types of things, you would want to go to the SBA website, which is www.sba.gov. Also the Treasury website, which is home.treasury.gov. Policy Issues CARES. That's long, but it's right there on the slide. That is some other coronavirus relief options. And luckily, I didn't go into great detail on the sources here because these were very easy to find. There's tons of information and places for people to go for help with coronavirus, especially financial type of things for this. Businesses could easily talk to their bank. People, everyone kind of is trying to help everyone during the COVID-19 pandemic. And that's it for me. And now we're going to go on to Tyler.
All right, my name's Tyler, and what I'll be going over is intellectual property, independent contractors, and e-commerce. So first, what is intellectual property? Intellectual property is basically any creation from human intellect, whether that be a sound recording, drawing a picture, or writing a symphony, for example. Those are all products of human ingenuity, and that is what is considered intellectual property, which is granted through the Constitution. And there's three big areas of intellectual property. That is patent, copyright, and trademark. Those three pillars have a pretty robust body of law. During the presentation, the case study will be Tigris LLC. So this will be a new online retailer that is meant to compete against Amazon. So first off, the Washburn Law Clinic doesn't do patents, but I think it's important just to have a surface level knowledge of what a patent is. And a patent's basically just an invention or a process that creates something useful. That's good enough for the purposes of today. On copyrights, the first thing to ask is what is copyrightable subject matter, meaning what can be copyrighted. Generally speaking, what can be copyrighted is any literary work. So if you write a book, you can get that copyrighted. Any musical work, dramatic works, or anything that you can put from pen to paper or fix into some sort of tangible mean. As far as the formalities go, notice used to be required. However, registration is no longer required. So if you write something down on a piece of paper, you do have a protectable copyright. However, if you wanted to enforce that, it is way more useful to have that registered because you can get statutory damages. And the duration of the copyright is 70 years plus the life of the author, or 95 years from first publication if it's an anonymous work. So there are three main rights that a copyright has. So if our company Tigris wanted to sell online music, they should be aware of what rights the owner has. The first one is the reproduction right. And this is the one that most people would think of. You have a right to prevent people from illegally reproducing what you made. So if you create a CD with your music on it, someone cannot then go copy that and make it for their own. Second, derivative works. So a good example would be Rocky 1, 2, and 3. If you wanted to go make another Rocky film, that would be violating the derivative works right of who owns that. And third is the distribution right. So the owner has the right to control the sale and distribution of the original. And the important thing to note is they can only control the first sale. So if you go buy a CD from the music store, the copyright owner could control that sale. However, they then can't control downstream transactions. So if you were to buy the CD and sell it to someone else, you would not be violating their distribution right. And there's also the so-called moral rights, and you have the right to prevent your work from being vandalized or distorted. So if you create a statue of some sort, you have a right to prevent that from being vandalized. And two big things that distinguish copyrights from patent law is patents, it's all about excluding. You can exclude someone from using your invention. That is not the case with copyright law. Copyright law, you cannot exclude someone from it. You can prevent them from copying, distributing, or creating derivative work, but that does not come with excludability. And the second big difference is a patent is only valid for 20 years. A copyright, as we discussed, is valid for 75 years plus the life of the author. However, that's very fluid, mainly because there are many big companies that lobby Congress to increase that number. For example, Disney. Disney wants to keep their copyright on Mickey Mouse. And early 2000s, Congress changed the law at their behest to have them keep their rights in it. And I think now it's going to be up in 2030, 2040, I think. And it's going to be interesting what Congress does with copyright durations at that time. Copyright has one really big defense, and that's fair use. So there's a few situations where fair use. One big one is educational. So you could play your music in class if it's for educational purposes. Parody, you could create a parody of a song. This is usually protected because of the First Amendment. There's usually some sort of protected speech or message you're trying to convey with a parody or a satire. So that would also be protected as fair use. Let's say that Tigris wants to create a trademark, maybe similar to Amazon, maybe not. So the basic idea of a trademark is you're creating some sort of design mark just to distinguish your goods or your product or your service. You're trying to create the connection from the public that whatever you're selling comes from your business. And when you want to file a trademark with the United States Patent and Trademark Office, the first thing you do is you can either file an intent to use the trademark, or you can file an in-use application. And the difference is, for example, if you have a service mark, you need to actually be rendering those services. So you can't just have advertisements out. You need to actually be transacting in interstate commerce. If you have not done that yet, you'll want to file an intent to use trademark application, because that will keep your priority. So if someone files something after you, you'll take priority with that mark. After you file an intent to use, you will have 6 months to either have a 6-month extension or to file a statement of use, which will basically transfer into an in-use application. And as I mentioned, service marks, this is essentially the same thing as a trademark. Just a service mark is about services and a trademark is about goods. So if you're selling a product, a trademark is more appropriate. Whereas in the Tigris case, where you're an online retailer, you're providing a service, so a service mark is appropriate. And there are 4 levels of classification. The first and most protected is arbitrary or fanciful. Second is suggestive marks, 3 descriptive marks, and 4 is generic. A little bit more detail, a generic mark is not protectable. So for example, aspirin. If you wanted to sell some sort of aspirin and name it aspirin, the USPTO would not allow you to do that because that's a generic mark. And that would just confuse the public of what is the good and what is the brand. A descriptive mark can be protectable in certain circumstances, and that's if it has acquired a secondary meaning, and we'll get into that. Third is suggestive, that is protectable, and for example, copper tone, that is suggestive. And then fourth and the most protected is arbitrary or fanciful marks. So a fanciful mark is something that bears no relation to the product. For example, Kodak, that's a fanciful mark. An arbitrary mark is something that's a real word, but isn't connected to your good or service. For example, Apple. So if you were an Apple company selling apples, that would be generic and that would not be protectable. But because of the context and because Apple is an electronic company that sells those sorts of products, Apple is actually arbitrary and is the most protected. Getting the secondary meaning, if you recall, I said descriptive marks are sometimes protectable, sometimes not. Well, it needs to require a secondary meaning. And the secondary meaning is required when you, the public, have come to understand the name of that word to come from the source. So an example, Coca-Cola. Coca-Cola is descriptive because it comes from coca leaves. However, chances are you and the public, when you think of Coca-Cola, you think of the source, as in who is making the Coca-Cola. Therefore, it has now reached protection. And another good example is American Airlines. That's about as descriptive as you get. Airline flights in America. However, it is now protected because it's quite a secondary meaning. The public has now come to understand American Airlines to mean the company. So that is why it's now protected. And defenses are similar to copyright. There are some differences. For example, news reporting and news commentary. So if you display a mark while reporting the news, that's not going to be infringement. And there's also non-commercial use. So if you're using, for some reason, the mark and not making money from it, that's going to favor not infringing that mark. And lastly, on the intellectual property is trade secrets. So the biggest body of law is the Uniform Trade Secret Act that most states have adopted. For example, Kansas has adopted it, the Kansas Uniform Trade Secret Act. And there's 2 elements. First, you must have a valid trade secret. And second, it must have been misappropriated. And a big difference between trade secret and say copyright or patent is a trade secret is valid for as long as you can keep it a secret. So theoretically, it can be valid forever, but that's contingent on keeping it a secret and taking steps to prevent its disclosure. So a trade secret is information that's not generally known and you've taken reasonable precautions to prevent its disclosure. And the reasonable efforts don't need to be absolute. You don't need to take every single precaution, but it does need to be reasonable under these circumstances. And second, it must have been misappropriated, meaning it was wrongfully required. So if someone broke into the office and stole your grandma's secret recipe, that would have been misappropriated. And the defenses for trade secret are actually very important. One is proper means of disclosure. So if a whistleblower does something, that's going to be a legitimate defense. But the big one is reverse engineering. It needs to have been, if someone takes your, say, recipe and reverse engineers it, that is valid and that is not misappropriated, and you would not have a cause of action against that person. Same thing of independent invention. If you independently came up with that trade secret, there's again no cause of action. And I do want to emphasize that these be proper means of disclosure as well. So when someone misappropriates something, if they come to acquire the information by, say, aerial recon, there's a number of cases that say that is too far. And even though you're able to reverse engineer it based on certain methods, it needs to be an industry norm. Next topic is independent contractor versus an employee. And this is important because there's big implications on whether that person is classified as an employee or independent contractor. So a big company like Tigris, an online retailer, could have people working for them in marketing, driving trucks, on customer service lines. So are these people employees or independent contractors? And there's no bright line. There's a bright line as how you classify them. You have to classify them as one, but how a court will find it if it gets litigated is how if you offer them benefits, how are they paid? Are they paid through your company account? How much skill is required? Are they doing it for one project or are they doing it in multiple projects? How long are they working for you? The more permanent and the more higher skill level that's involved, the more likely they're going to be considered an employee. However, if they're not working as the same location as other employees, if the duration is shorter, they're more likely going to be an independent contractor. So why would that matter? Well, first, if you get the classification wrong, the IRS can really hit that company hard. And you'll often have to pay back taxes, and the penalties are probably going to be even higher than those back taxes. So there's going to be pretty harsh penalties on that. And this is extremely relevant, for example, Uber and Lyft drivers. Uber and Lyft drivers currently are considered independent contractors. However, lately there's been a push to have them considered employees, because then Uber and Lyft would have to pay employee benefits, potentially healthcare, and different items. And that would essentially make Uber and Lyft probably bankrupt in 1 week. So, it would probably resort back to a taxi cab industry. So this can have real ramifications. And as a side note, another big thing about Uber and Lyft is there's some litigation going on whether or not their driver lists are trade secrets. And we don't have time to get into that, but it's just something to keep in mind that all these things are interrelated, and intellectual property is something that's very important that goes into the fields of small business. And another big implication is an independent contractor has rights in the works that they create. So if you hire someone to make a painting, for example, and they're an independent contractor, they're going to have rights in that. However, if it's an employer-employee relationship that's made within the scope of their employment, then the small business or whoever employs that person would have rights in that work. And this can mean millions of dollars depending on what you're hiring someone to do. And if you're unsure that if there's an independent contractor or employee, the simplest thing to do is put in the contract. If it's in the contract that you retain the rights, then you'll have the rights. And then lastly, the e-commerce. And as I said, this is all interrelated. And with technology increasing and the rapid digitalization of the world, people are trying to protect their copyrights on the web. You've seen websites shut down because of copyright infringement. And it's important to be aware and take precautions when wanting to protect your intellectual property rights in the e-commerce sphere. And copyrights are in the e-commerce realm can be used to protect the design and creative designs of a website. So any text, images, or graphics. Trademarks have huge importance in e-commerce because that's how goods and services are transacted online. You'll see the trademark and the consumer will know where that comes from. And we won't get too much into patents, but that can protect software in certain situations and also help your business. And a couple other big things is the Can't Spam Act of 2003. This is enforced by the FTC, and this creates standards for how businesses can communicate online. So you can't email certain consumers incessantly without breaking the law. And the final big one is how taxation works online. So you may notice that if you were to buy something from an online retailer, like our company Tigress wants to do, sometimes you may see that there's a tax applied and sometimes there might not be a tax applied. Well, that's because the rule is if your business has a physical presence or connection to the state that the customer is buying from, then you have to apply sales tax. However, if you don't have a physical connection to that state or don't have any nexus to it, then you don't have to have sales tax. So in the case of Tigress, if their headquarters is in Kansas, for example, and someone buys from Kansas, they're going to have to apply sales tax. But if someone buys it from Arizona and they don't have any connection to Arizona, then they would not have to. And that would conclude the small business and your legal issues. And with that, we will open it up to questions.
All right. So Mindy, if you're out there, I think our protocol here was for folks to raise their hand or ask to be unmuted to ask a question. So anybody that wants to do that, we're ready. Or pose it in the Q&A. Any questions out
The
there?
students were so crystal clear about everything. They answered any question that anyone had. That's entirely possible.
That is very possible. Although, Tyler, I always love the intellectual property piece. To me, some of that gets rather confusing. Okay, here we go. Mindy, are you want to facilitate these questions?
Yes.
Or okay. That's what I
So
thought.
the first question is, can you please list the components for operating agreements?
Jesse, do you want to take that? You can start. I can help you out if needed.
Jesse, you're muted.
She's trying.
Okay.
I think she's having. Let's see if she can get it. No, we still can't hear you. It's not working. Okay. So I will take that unless, do one of you want to, Sherilyn or Tyler, do you want to talk a little bit about an operating agreement? No? All right. So an operating agreement is the governing document for the limited liability company. It is akin to bylaws for a corporation. And it has not only who are the members, but what their capital contributions are. What's going to happen if someone dies? How are interests, what would be shares in a corporation are called interests, member interests in a LLC. So how do those interests get transferred? All of those sorts of issues are in an operating agreement. Basically, anything that can create a question as to how the company is going to be operated, you want to try to anticipate that as much as possible and have that in the operating agreement, including if there's a conflict between the members. Are we going to go to alternative dispute resolution? How are we going to try to resolve that? So all of those issues are included. and more.
Is there a chance that Topeka may change their LLC taxing?
Well, that was the case in the past when part of former Governor Brownback's experiment was to get rid of the taxation for limited liability companies, and we saw a ton of people forming LLCs at that time. I've not heard that without getting into the politics of that, I'll just say I have not heard that that's going to happen again. So I am not aware of any changes, any planned changes to taxation. Carl, I don't know if you've heard anything.
I'm actually on the legislative committee with our chamber, and I have not seen any inkling of change in taxation methodologies coming up in the new session. So, not to say that I couldn't be wrong, though, that somebody couldn't do that, but I haven't seen anything.
Yeah, I'd be surprised, actually.
Mm-hmm.
Can you tell us the link to register for an LLC in Kansas?
Now, I know the students have that. Do you know?
I was just going to say, I don't know it off the top of my head, but certainly is easy enough to get and send to anyone.
Who is the, what agency do they go to?
The Secretary of State.
The Kansas Secretary of State.
Yes.
And it should be kssos.org, actually.
Oh, that's true. I didn't want to I thought they meant like the specific, click on it and it takes you right to that.
Well,
but yeah, if you go to the Kansas Secretary of State website, there's actually tons of resources, and it would be fairly easy to navigate to that where you can file for an LLC, but there's also just tons of resources there.
So just for clarity, kansasbusiness.gov is the actual URL of where you would go to register. But you also, before you actually register, you have to sign up through Access Can to pay online or do the registration online.
Okay, there you go.
What is the primary advantage of an LLC over an S Corp?
Well, that is a good question. Jesse, do you want to, can you talk? She still can't, okay. That's a good question. We get that a lot. The difference is that you are, as Jesse explained really well, an S Corp is simply the taxation treatment of a corporation. So the question that you really want to ask is, do I want a corporation as my entity, or do I want a limited liability company? And the requirements for a corporation are different. One of the reasons that people really love LLCs is that they offer a lot of flexibility. People say, well, they're the best of a partnership and the best of a corporation put together. And so it gives you the protection, that limited liability protection of an entity, just like a corporation, but it actually gives you the pass-through taxation of a partnership. Now, an S corporation, you would say, also has pass-through taxation, but it also has the other elements of a corporation, which are less flexible than a limited liability company. So if you look at the Limited Liability Act in Kansas, it pretty much says you can, as long as you are operating this legally and you are not operating as an insurance company or I think a cemetery, you can pretty much do this any way you want. Whereas with a corporation, you're still bound by the corporate structure and the corporate requirements, including having an annual meeting and things like that. With the limited liability company, you can structure it much more freely. So most people choose that. Some of the reasons maybe to choose an S Corp over a limited liability company is if you know that you are a company that's going to go public soon, then it's much easier to do that. You don't have to, it's much easier to do that a lot of times from the corporate status than from the LLC status. So there's some other reasons. It also, some people want to well, you wouldn't be an S Corp in that case, but some investors may be more comfortable with the corporate status than an LLC. I think that's changing though.
If I'm selling a food item, do you recommend forming an LLC as well as buying additional insurance?
Anybody want to try that one? They're being very quiet today. Okay. A food item. I'm going to give you that typical lawyer's answer of it depends. So not everyone needs an entity, right? So, but pretty much everybody needs insurance in my estimation. So you have to think about, how is the actual entity protecting me? And how can it not protect me? So whoever asked that question is I think thinking along the right lines, in that if I serve something to someone and they get food poisoning, my entity is really not going to do anything to protect me, but that could be an insurable event under my food poisoning insurance. And so I can't answer specifically, because we would need to know about your situation in particular, and we wouldn't be able to advise you, if you're not a client of the clinic, whether you should actually form an entity as in addition to getting insurance. It really does depend, but I would say in almost every case, you need insurance.
If I set up an LLC, can the Washburn SBDC or the legal clinic check the paperwork to make sure it's been set up correctly?
The clinic can do it if you qualify as a client of the clinic. So our qualification is first, that you have to be financially eligible. We only help people who cannot afford to pay market rates for an attorney. So we represent the entity, and we do look at the entity assets, but if the entity isn't built yet, if it's not formed yet, and you're investing in your company, then we would have to look at the owner's assets as well, their finances. And so we would have to go through a process of a financial evaluation. Otherwise, if it's an appropriate project for the students to do in a semester's time, or to be able to transfer, then generally those are the requirements. So we would have to look at the financial eligibility, but otherwise, yes, we would be able to do that.
Can you go into a little more detail on what a service mark covers a business for?
I'm gonna let Tyler handle that.
Yeah, sure. So a service mark is going to cover the logo, and the business name. It can protect your business name in that industry or field. For example, Amazon, it protects the use of an online retailer using the word Amazon. However, it doesn't ban the name Amazon for other uses. So if someone wants to create a company named Amazon that would not have any effect on Amazon, then that would also be fine. So it's going to protect the design, the words you use, and the business name to an extent. And as far as specific to in-use, there's typically two requirements. First, it needs to be an interstate commerce. So for that to be satisfied, you need to have advertised across state lines or somehow reach a base that isn't purely intrastate. So you need to have a potential for clients to come from other states in the stream of commerce. And second, the services need to actually be rendered. So you actually need to take on clients for that to be considered in use.
You can also get a Kansas trademark.
And right. You could do a Kansas trademark, which comes with different things.
Yeah.
Okay, that's all the questions I'm seeing for now.
Hey, Mindy, let me add a quick correction there on the URL for filing an LLC. It's kansas.gov/business center. That's the actual URL to get there. And then I wondered, Janet, would you want to talk about the services that we connect businesses through your center and how that works? I know it's semester based and really next semester would be the time, but is that worth mentioning?
Yeah, absolutely. So we encourage you to contact the clinic if you have a for-profit business that you want to form. Probably the vast majority of people that we work with want to form a limited liability company, but a lot of sole proprietors come to us and don't want to or need to form a business, but they have some contracts that they want drafted, service contracts, employment contracts, membership, gym memberships and things like that. Licensing agreements. We do all of that, whether you're a sole proprietor or you're some kind of an entity. We also help you to figure out what kind of entity would be appropriate for you. We work with nonprofit organizations as well, forming them at the state level and helping them get tax exempt status and doing any of that kind of contractual or transactional work as well. Do you all want to talk about any of the other, without mentioning clients, the type of work that you're doing? Anything that I didn't mention?
You want us to just kind of like rounds, just go through, but don't mention any specifics?
Right, just the type, just to give them an idea of the type of work that you're doing.
So I have one client where we were helping them decide what type of entity they wanted to form, and then getting together and drawing up, drafting those formation documents, and then helping file them with the state. I have another client that is an organization that's been organized for a long time, and they just wanted some new, more enforceable, reliable, real specific liability waivers, which was a great experience for me. And then sometimes what happens, I have one client, she's trying to form an entity, she's trying to get a board of directors, she's trying to get herself together, and just because of COVID and communication and just different hurdles, which she is, attacking with a smile, we really haven't gotten much done, but we've just been available. And so sometimes that it doesn't just happen overnight. There are definitely things that can get in the way, but you just have to persevere.
So with a situation like that, Sherilyn is helping as much as possible, but we may need to transfer to other interns in the next semester. So what happens is that work doesn't necessarily get done over the winter holiday, but in January, when we get new students, they'll pick up where Sherilyn or Tyler or Jesse or my other students leave off, and hopefully finish the project at that time. So it's not unusual for people to transfer to another semester. We are not open for client work over the summer. So if there's something urgent that comes up and we need to deal with something, then I am monitoring that. But we don't take any new clients over the summer or do any active work over the summer. It's basically August when school starts through May.
And Professor, if I'm not mistaken, if I wanted to stay on to the next semester to handle that specific client, if it seemed like it was, I'm not going to, because I have no idea what, but if we were just on the cusp of success and finishing, I could continue on and wrap that up. And then even though we can transfer clients, isn't there a limit of 27 months or something?
Oh, that's for nonprofits. But that is true. If the student isn't graduating, then they do have an opportunity to stay on and to continue work with clients that they've worked with to finish some things up. And that's really convenient for the students and for the clients and for me.
So it does look like we have a few more questions that rolled in. I noticed that my registered company name with Kansas and the federal government is used exactly, except the LLC part, on a website selling the same product. Is my company protected?
Well, I'm going to be careful with that because again, we can't give legal advice there, but it sounds like you need to speak with someone. If someone is out there using your name almost exactly, then that sounds like you would want to get that checked out, because that could be possible infringement. I can't say whether it is or not because I don't know the circumstances well enough.
Okay, so this question is directed to Tyler. So a Kansas trademark or service mark would be what we would want for a tree service specific to Kansas customers?
So that would be dependent on your business. So there's a few differences between a state trademark and a federal trademark. For example, a state trademark is only valid within the state. So if someone from a different state were to be using that mark, you wouldn't have any sort of action against that person. And you also your infringement and statutory damages are also limited in the state. And if you notice, there's two types of trademarks. You might see the R with the circle around it. That means that's a federal trademark. And you might see the word TM, and that means it's a state trademark. And the R typically carries a presumption that you have a protected trademark, while a state trademark does not. So it depends on what kind of business you have and what's right for you. If you don't anticipate having people from other state infringing on your mark and you want a quick, less expensive way of protecting rights within the state, then I would say state service mark is a likely good option.
And let me also clarify, you can use that TM if you are not registered at all, but you are claiming trademark rights over a name. You can put a TM after that. And it indicates that it is not, you've not gone through the actual, either haven't gone through the registration process or it hasn't been accepted as a registered trademark yet.
Can you review the difference between a gig worker and creating an LLC?
A gig worker?
Yeah, I think it's referring to like people who do like side hustles. Maybe they're not particularly doing like a full-time job, but it's kind of a side hustle type of job.
Gig workers, typically independent contractors, basically.
Oh, okay.
Yeah.
So I'm not sure I understand the question though.
That's right.
Between a gig worker and an LLC. I mean, a gig worker, if they're an independent contractor, they're just an individual who is contracting with someone for services for a very specific job. And a limited liability company is actually an entity that can sue or be sued, that is recognized by the state as a legal entity.
I'm going to try to read between the lines and interpret that question.
Okay.
I think they might be referring to is a gig worker that's a sole proprietor or a gig worker that's a single member LLC. I don't know if that's what they're getting at, but that has potential there.
Right. So that goes to what Jesse was talking about. As a sole proprietor, you have no entity, right? And so you may have insurance that protects you, but you don't have an entity. The difference between an entity and a non-entity or sole proprietor, the entity actually acts as a shield of liability protection from you personally. When you're a sole proprietor, you don't have that shield. So that if you end up getting sued as a sole proprietor, hopefully you have insurance. And if insurance is able to pay off something, then that's great. Maybe it's not an insurable event, but maybe you have business assets that you can use to satisfy some kind of judgment. Great. If you don't have any of that, then that's where we start getting a little bit nervous, because as a sole proprietor, you have nothing to protect you from your personal assets, your personal bank account, your house, whatever asset you are being used to satisfy a judgment, because you have no entity that is shielding you. So and a partnership is the same way. A partnership is not doesn't shield you. If you're a limited partner, then you are protected up to the amount of your contribution. But a corporation A limited liability company, those are entities that actually act to shield you. They separate you from the business. So the business has its own entity, and it's being sued. Now, that is not to say that there are not things that can happen where your entity isn't going to protect you. And if you've done something and it's your own gross negligence, then you still may be liable. But generally speaking, we form that entity so that it's separate from you. I hope that answers the question. As an independent contractor, normally, if I'm reading this right, as an independent contractor, you are acting kind of more as a sole proprietor, in that you're just signing off on to contract to do some work for someone. Carl, I don't know if you want to add anything to that.
Yeah, that was a great answer, Janet. You really covered it well. Thank you.
Okay.
I think that was excellent. Okay. I think we should conclude this endeavor, huh? You guys did a great job. Thank you so much. Really appreciate everybody and the work that they did. Mindy for the facilitation. And if you have any last words, Janet.
I just want to, Carl, thank you and the SBDC for giving us the opportunity to bring this to the public once again. Thanks everyone for being here who's participating. Mindy, thank you very much for facilitating this. And I want to thank the students for doing a great job and really preparing hard to get this information out.
Yeah, awesome job, guys. Have a great Thanksgiving coming up. Y'all take care.
Thanks, you too. Bye-bye.
Yep.